Garden State GSCLE. 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 Garden State GSCLE.
So I think the central issue that everybody should get out of this today is the following. This is why we call this barely legal. In American society, the science, the technology, the disruptive technology is moving so fast that we really just can't keep up to it. You know, you guys have all heard of Moore's Law about the speed of processing. Moore's Law applies to a lot of things in technology. For example, the cost of online storage and things like that, which is now virtually zero. And this impacts us in New Jersey because the technology, your capabilities, the tactics and strategies related to marketing and advertising are moving way, way, way light years ahead of the law. The law can't possibly keep up to it. So what we're going to do today is talk about tactics and strategy that are available to you as marketers of your own law practices, and then compare them to what is permitted under the current New Jersey law. And if you're going to challenge some aspect of New Jersey law, and believe me, a lot of it needs challenging, you're going to have a basis for doing it. The most important thing is I don't want to see anybody in here engaged in some type of conduct that could get you jammed up inadvertently or otherwise on some type of advertising that you would undertake. So you'll walk out of here today with a complete, firm knowledge of what's going on, plus a resource center that you can go to in your materials if you have a question on something or you want to research something. Procedurally, substantively, you'll know what's happening. Now, one of the new tactics and strategy that's being utilized is this concept called leveraging. You got to remember, the last time the New Jersey Supreme Court talked about advertising in the context of television, I think might have been 1986. It's an opinion written by Chief Justice Wilentz, which we'll talk about. We're in a completely different world today than we were in 1986. And one of the tactics that's utilized today is called leveraging. Leveraging means that you take advantage of a television advertisement and use the internet to leverage the TV commercial. Or sometimes, alternatively, we have lawyers in New Jersey who take the internet and then leverage it onto television. And you kind of go back and forth. On Super Bowl Sunday of 2014, there's a little rinky-dink local market somewhere in the middle of Georgia. It's about the size of Maywood, this town. And there's a local attorney who decided that he would buy an ad on the local Fox affiliate that was showing the Super Bowl that day. So he bought 2 minutes worth of advertising on the local station because, you know, they have local spots that run during the Super Bowl. And I'm sure he paid a top dollar for the 2 minutes. It's kind of like the Steve Jobs, 1984 ad. He was going to only run it one time because he had a marketing plan. He was going to take this ad, create a huge splash on it nationally, as you'll see why in a moment, and then leverage it into the internet. We're going to take a look at this ad now, but I want you to keep something in mind two things in mind when you watch it. He might have had an audience of, let's say, 100,000 people, which would be huge ratings for that little station on the day that he watched it. The last time I checked on this ad last week on YouTube, it had 5.5 million views from all over the world. Okay, this is real, true leveraging. And the interesting thing I want you to think about when you're watching this, you say to yourself, gee, would this fly in New Jersey? If I ran this ad in New Jersey, would I get in trouble? And the more salient question is, if I ran this on television, would I get in trouble, or would I be okay if I ran exactly the same ad on the internet? Okay? Now, having said all that, let's take a look at this ad.
I'm Jamie Casino. You may have seen some of my personal injury commercials on TV. I wasn't always a personal injury lawyer. I once was a notorious criminal defense lawyer who was employed by some of the most cold-hearted villains. My art brought me great wealth until one day my little brother Michael and his friend were 2 of 4 people whose lives were taken.
Your brother was involved in a situation last night. He was shot. He didn't make it.
After the tragedy, our chief of police deceived you to make it look like the police department had lost control.
No innocent people were targeted.
Daddy, what do you do when you go to work?
At some point, a man must ask why God created him. I'm attorney Jamie Casino, and I don't represent villains anymore. I speak for innocent victims who cannot speak for themselves.
I want to kind of hold off on our discussion for a second as to whether or not this guy would be jammed up bad in New Jersey if this were to run on television as opposed to running on the internet. One quick thing you'll see is that he had very effective use of music. It's kind of like WWE type use of music, but he had use of music on the TV ad. You'll see in a few moments, New Jersey, it's against the law to use music in a television ad, not against the law to use it in an internet ad. But we'll come back to that, all right? Now, having said all that, let's get into some law, and I want to spend just a couple minutes to discuss the development of the law related to attorney advertising in the United States, starting off with 1942, Valentine versus Chester. This is not good law anymore, but it's the starting point for our analysis because this was a kind of a general pronouncement by the United States Supreme Court that there was no constitutional right to engage in commercial speech. In other words, political speech certainly was protected, all kinds of other speech protected, but speech that was purely commercial in nature was not entitled to any type of constitutional protections. As a result, they could be prohibited, controlled, banned outright in certain instances. This was the position that the court took in 1942. That changed, though, dramatically in 1976 in Virginia Board of Pharmacy versus Virginia Citizens Consumer. This dealt with advertising the prices of certain medications in pharmacies. This is a landmark decision because this is the first recognition in the history of our country where the Supreme Court denominated speech as commercial speech and then said that it is entitled to a level of protection under the Constitution. Now you'll see as we go through this, and this is the law even today, that commercial speech, although it is protected, is not entitled to the same level of protection that you would get for, say, political speech. In other words, that the amount of control or regulation that commercial speech is subject to is significantly more than you'd be entitled to, say, for commercial speech. Here's the holding of the case. Recognize commercial speech as protected by the First Amendment, applicable to the states under the 14th Amendment. In this case, the justice invalidated a statute barring pharmacists from advertising prescription drug prices. At issue was prohibited commercial speech that involved the idea, I will sell you X prescription at Y drug prices. So this is advertising that was truthful, meant to get prices out there, and the Supreme Court found that this is something that was beneficial, entitled to protection under the Constitution. Bates versus State of Arizona Bar Association is the first dip in the water, so to speak, of the concept of commercial advertising for attorneys, okay, and whether or not attorneys will be entitled to commercial speech protections under the 14th Amendment. Now, let me just tell you what happened in Bates. Bates involved a guy who was doing newspaper advertising in Arizona, which was a practice that was totally banned at the time. The petitioners in this case had a legal clinic and made a determination that they were going to not only publish in the newspaper what their activities were in terms of what they did, but also the fees associated for some of the things that they did at the clinic. So I guess this is one of these clinics that serves, you know, working people and poor people, because the things they're advertising were all kind of like consumer-oriented legal services, things like adoptions and divorces, name changes, simple bankruptcies. This is the type of thing that they were advertising. So, of course, the Bar Association at the time, the State Supreme Court in Arizona, had its prohibition on newspaper advertising for attorneys. So here's how the Supreme Court dealt with this. And again, remember, this is the starting point for our analysis today. Constitutional issue of this case is only whether the state may prevent the publication in a newspaper of appellant's truthful advertisements concerning the availability and terms of routine legal services. We rule simply that the flow of such information may not be restrained, and we therefore hold the present application of the disciplinary rule against appellants to be a violation of the First Amendment. Now notice the key things here is that the information they're giving is truthful. It's not deceptive. Everything they've said in terms of their commercial pitch, so to speak, was in fact based in truth. In holding that advertising by attorneys may not be subject to blanket suppression and that the advertising at issue is protected, we of course do not mean to hold that advertising by attorneys may not be regulated in any way. We mentioned some of the clearly impermissible limitations on advertising not foreclosed by our holding. Advertising that is false, deceptive, or misleading, of course, is subject to restraint. Since the advertiser knows his product has a commercial interest to its dissemination and will have little worry that regulation will assure truthfulness, will discourage protected speech. And any concern that strict requirements for truthfulness will undesirably inhibit spontaneity seems inapplicable because commercial speech generally is calculated. Indeed, the public and private benefits from commercial speech derive from confidence in its accuracy and reliability. Thus, leeway for untruthful and misleading expression has been allowed in other contexts, has little force in the commercial arena. And by the way, this precise issue was argued before the United States Supreme Court this week in the political context, right? Whether or not you can have false, misleading statements, lies for that matter, in the political advertising.
But enough of that Fox News.
Well, we'll see well, that's what they say. As well as the varieties, you know, you're such a commie too, and you're just such a nice guy. How can you be such a commie? But I digress. As well as varieties of speech, it follows as well that there may be reasonable restrictions on time, place, and manner of advertising. You get the same thing for just political speech too, time, place, and manner restrictions. Advertising concerning the transactions that are themselves illegal obviously may be suppressed, and special problems of advertising on electronic broadcast media will warrant special consideration. So you see the limitations on this decision, really, you got to look at it very narrowly. We're dealing with truthful advertising occurring in a newspaper. That is protected by the First Amendment as commercial speech. This is the beginning, this Bates, and you'll see Bates cited in every case after this. Now, O'Ralick versus Ohio Bar Association, this is a case that is still good law today. This is very, very sensitive. And it deals with a guy who is just, you know, certain attorneys like give our profession a bad name. I mean, they're just awful people, you know.
What we have here is a clear case of negligence. We are going to sue the school system. We are going to sue the city. We are going to sue the state. And we are going to sue the bus driver. Now, what you boys need are some top quality x-rays.
Cool.
Here you go, son.
I'll see.
Now it's starting to look like we got ourselves a case of whiplash.
That's this guy, all right? Even to this day, everybody would find what he did completely distasteful. He heard about, somehow, either read in the newspaper or somebody told him about an accident, a very serious accident, involving two little girls, 18 years old each. So you got a driver and you got a passenger. He goes to the parents, unsolicited, talks to them, says what a great lawyer he is, finds out where the daughter is at the hospital, goes to visit her. Again, he's a stranger, okay? Importunes her to sign a retainer agreement. She's like too sick to do it. So he comes back a couple days later, once again, importunes her to become a client. She signs the retainer agreement, okay? Then, you know, he's not satisfied with one client. Now he wants to find the girlfriend. So he finds the other little girl and gets an oral commitment out of her to represent her as well, okay? So he undertakes representing them. Once these girls get out of the hospital, they talk to their parents when they're not under anesthetic. They make a determination, this is not the guy we want, you know, representing us on our PI case. So both little girls, they discharge this guy as their attorney, and they go and hire another lawyer, all right? So you would think, well, that should be the end of the case. No, it's not the end of the case, because the girls get settlements, you know, and he sues them for his cut of the recovery, okay? I mean, you know, I know greed is good, but sometimes, you know, not all that good. So this results in a complaint against him, and the gravamen of the complaint is that this guy solicited us personally, face to face, put undue pressure on us to become clients of his at a time when we were very, very vulnerable. His defense is, hey, this is protected speech. It's commercial speech. Instead of broadly, spreading the word, I'm individually talking to people. And I have a right under the First Amendment to communicate with individuals. Everybody got the setup? All right. You can predict where this is going to go. Here's what the United States Supreme Court says. Appellant contends that a solicitation of 2 young women as clients is indistinguishable for purposes of constitutional analysis from the advertisements in Bates. Like that advertisement, his meetings with prospective clients apprise them of their legal rights and the availability of a lawyer, him, to pursue their claims. According to the appellant, such conduct is presumptively an exercise of free speech rights, which cannot be curtailed in the absence of proof that it actually caused a specific harm that the state has a compelling interest in preventing. But in-person solicitation by professional employment by a lawyer does not stand on a par with truthful advertising about the availability in terms of routine services, let alone with forms of speech more traditionally within the concern of the First Amendment. Now, what you're going to see here, and this is good law in New Jersey to this day, this concept of in-person solicitation of an individual, face-to-face, orally soliciting them, puts an undue amount of pressure on the individual who's the target of this solicitation. This is why you're going to see that this is something that can be banned by the states, as because of the unfair advantage it gives to the attorney, especially when the people are vulnerable either because of illness or some other life catastrophe that has confronted them. A lawyer's procurement of remunerative employment is a subject only marginally affected with First Amendment concerns. It falls within the state's proper sphere of economic and professional regulation. While entitled to some constitutional protection, appellant's conduct is subject to regulation in furtherance of important state interests. Because appellant's statements were not false or deceptive, our decision to impose on the state the burden of establishing that prohibited use of such statements to solicit or obtain legal business directly advances a substantial governmental interest. All right. Now, I just want to give you a couple cross references as we go through this, so you'll kind of be aware of New Jersey law. The main case, although it's certainly not the first one to come along, is Pajaworski. This wound up being a disbarment case. This guy had a whole string of runners that he had going out soliciting people inside of hospitals for this purpose. The bad thing about the Pajaworski case is that he had a whole bunch of other ethical issues that were unrelated to the use of runners. So they wound up disbarring him, and it might have been on the totality of all the stuff that he had been engaged in. It's hard to say whether or not the use of runners would be a per se disbarment type case. It's just not clear from reading the opinion. It was just one of the other factors they thrown in. But you'll see, I'll show you the statute in a moment. It's actually criminalized activity in New Jersey at this point. 1980, the Central Hudson Gas case is not an attorney case at all, but it's critically important because here is the test for the first time that the United States Supreme Court established to gauge what is commercial speech and the parameters of commercial speech, okay? So you'll see that there's a 3-part test that the court gives to determine whether or not a regulation of commercial speech is reasonable under the circumstances. And the Central Hudson Gas test is the test that's utilized in all commercial speech cases to this day, generally and specifically in attorney commercial speech cases. So here we go. Government may freely regulate commercial speech that concerns unlawful activity or is misleading. Such speech is not constitutionally protected. However, commercial speech that is neither related to unlawful activities nor misleading may be regulated if the government satisfies a test consisting of 3 related prongs. This would be truthful commercial speech involving attorney advertising, okay? Here they are. 1, government must assert a substantial interest in support of its regulation. 2, government must demonstrate that the regulation on commercial speech directly and materially advances that interest. And 3, the regulation must be narrowly drawn. So you can see, if you go back to the context of banning opportunities by lawyers to solicit individuals face-to-face, and apply this test to it, you can see that it's going to wind up being rejected. The government asserts a substantial interest in support of its regulation, which they do have an interest in making sure people make a decision to get an attorney at a time when they're thinking clearly as opposed to having pressure put on them. The government must demonstrate that the restriction on commercial speech directly and materially advances that interest, which it would do. And 3, the regulation must be narrowly drawn. In other words, it's just face-to-face live speech. We're not talking about television, radio, or other types of communication, Twitter, or something of that nature, okay? And you'll see this is the test that's going to be adopted and used in the context of attorney commercial speech, both in New Jersey as well as federally. The next adventure was in 1982 in a disciplinary case called In Re RMJ. This is another newspaper advertising case, and it involved both newspaper as well as had a component of use of speech in the mail. Now, Arizona at the time had very, very narrow, detailed restrictions on advertising. So, for example, if you're going to advertise in the newspaper and you have a particular practice area, the only practice areas you were allowed to mention is one of the 23 specific practice areas that were allowed under their state regulation. In addition, you couldn't even deviate from the language that they had approved. So this is like a bureaucratic nightmare. We'll tell you what your practice area is that you're allowed to talk about, and we'll tell you the exact words you can be utilizing to describe that. Secondly, in terms of business card announcements, you can put out all the business card announcements you want and mail them, except you can only mail them to clients, former clients, friends, and relatives, and other attorneys. That's it. Members of the general public are not allowed to receive these types of practice opening, moving, closing, congratulating ourselves, Christmas cards, all that stuff prohibited, okay? So in this particular case, the attorney who's subject to this disciplinary action, he violated the law. He did two things that were bad. Number one, he put down a practice area that was not included in the 23. He utilized language that had not been approved by the court, and he also had sent out cards in the mail, but he sent them to people other than friends and relatives and other attorneys, okay? So here we go. Information lodged against the appellant, charged him with 4 separate kinds of violations, listing the areas of his practice in language or terms other than that provided by the rule, failing to include a disclaimer, listing courts and states in which he had been admitted to practice. Yeah, you're not allowed to do that under their regulation. You're not allowed to say, truthfully, by the way, I'm admitted to practice in Illinois and in Missouri. Mailing announcement cards to persons other than lawyers, clients, former clients, personal friends, and relatives. Appellant makes no challenge to the constitutionality of the disclaimer requirement, so we pass on to the remaining 3 infractions. Now you see where this is going to go, at least you should be able to at this point. Commercial speech doctrine, the context of advertising for professional service may be summarized as follows, and this is the correct statement of the law to this day. Truthful advertising related to lawful activities is entitled to the protections of the First Amendment. But when particular content or method of advertising suggests that it is inherently misleading, or when experience has proven that in fact such advertising is subject to abuse, the states may impose appropriate restrictions. Misleading advertising may be prohibited entirely. Duh, because it doesn't advance anything, okay? It doesn't serve any useful purpose for the public. Whether that's true in the political context, that's another issue. But the states may not place an absolute prohibition on certain types of potentially misleading information, for example, listing areas of practice, if the information also may be presented in a way that is not deceptive. Thus, the court in Bates, which we saw a few moments ago, suggested that the remedy in the first instance is not necessarily a prohibition, but preferably a requirement of disclaimers or explanation. Although the potential for deception and confusion is particularly strong in the context of advertising professional services, restrictions upon such advertising may be no broader than reasonably necessary to prevent the deception, okay? Now, just as a cross-reference, we're going to see in a few moments, our rule in New Jersey for dealing with this is set forth in RPC 7.4, but how you go about communicating your fields of practice. And we'll talk about that momentarily. Zouder versus Office of Disciplinary Counsel, 1985. This is another newspaper case. Now this guy, he did a couple different things. Number one, he put in the newspaper, Joe, you'll like this, he's a DWI defense attorney.
Hey.
Well, but he went one step beyond you. I mean, you don't advertise in the newspaper, but have an ad that says, I'll represent you in your DWI and I'll refund your fee in full if you get convicted.
That doesn't make it a contingency fee at all.
No, not at all.
No.
So that was one thing. Second thing he did is he started advertising for, and this is so common today, you'd think, what could be possibly be the problem? He starts advertising for women who had been injured as a result of the use of the Dalcon Shield. Do you guys remember the Dalcon Shield? I guess it was a products liability situation more than anything else. Now, according to his Supreme Court of Ohio, he was stirring up business, okay, making trouble by going out and trying to solicit clients who may have been injured by this Dalcon Shield. Beyond that, in his newspaper advertisement, trying to get clients who've been injured by this, he had pictures, diagrams of what the Dalcon Shield looks like, how it could injure you. You know, it's kind of descriptive that way. Now, according to the Supreme Court of Ohio, you're not allowed to be stirring up trouble looking for business. You're creating your own market, basically, for legal services, which you can't do. And you certainly can't be using pictures and diagrams in an ad. God, that's terrible. So, all right, everybody got the setup here? So here's what the United States Supreme Court says. Newspaper with illustrations of the Dalcon Shield, fees and fee refunds on DWI cases, prohibition on soliciting legal business through advertisements containing advice and information regarding specific legal problems, restrictions on the use of illustrations of attorneys by lawyers, disclosure requirements. Oh, that's just what the case is about. Okay, here we go. Because the appellant's statements were not false or deceptive, our decisions to impose on the state the burden to establish that prohibition of such statements to solicit or obtain legal business directly advances a substantial governmental interest. Now, what you're going to see from this case is that there is no problem with them putting a restriction on contingency fees, okay? The contingency fee issue with the drunk driving actually was not very well contested here. He knew that was a loser and would be a loser with the Supreme Court. But the idea of generating business and saying you're available to do this and helping people and utilizing illustrations, you're going to see this is going to become protected speech. Were we to accept the state's argument in this case, we would have little basis for preventing the government from suppressing other forms of truthful and non-deceptive advertising, simply to spare itself the trouble of distinguishing such advertising from false or deceptive advertising. The First Amendment protections afforded commercial speech would mean little indeed if such arguments weren't allowed to prevail. Our recent decisions involving commercial speech have been grounded in faith that the free flow of commercial information is valuable enough to justify imposing on would-be regulators the cost of distinguishing from truthful and the truthful from the false, the helpful from the misleading, and the harmless from the harmful. The value of information presented in the appellant's advertising is no less than contained in other forms of advertising. Indeed, insofar as appellant's advertising tended to acquaint persons with their legal rights who might otherwise be shut off from effective access to the legal system, it was undoubtedly, this is such great stuff, Joe. This is like the stuff you believe in so fervently. You know, I like reading this stuff. Reminds me of you. With the legal rights who might otherwise be shut off from effective access to the legal system. It was undoubtedly more valuable than many other forms of advertising. Prophylactic restraints would be unacceptable as applied to commercial advertising generally, are therefore equally unacceptable as applied to the appellant's advertising. An attorney may not be disciplined for soliciting legal business through printed advertising containing truthful, non-deceptive information and advice regarding legal rights of potential clients. Now, you see this today all the time in the television context where people are looking for, you know, mesothelioma and what are some of the other stuff they look for?
Asbestosis.
Asbestosis. They had one the other day where they have these, you know, these hormone things that you put on yourself. Did you hear about that? Testosterone. Yeah, it's testosterone. It's like people, they have this thing, low T now, you know.
Axiron can restore T levels to normal in about 2 weeks in most men. Serious side effects could include increased risk of prostate cancer, worsening prostate symptoms, decreased sperm count, ankle, feet, or body swelling, enlarged or painful breasts, problems breathing while sleeping, and blood clots in the legs.
Then they find out that it kills you. If you have heart disease or if you've had heart surgery, things like that, it can result in you know, additional heart attacks or death. So
picky.
I know. So, but I mean, you see on television advertised all the time, people trying to make a market, basically, you know, trying to acquaint people that they may have a cause of action. And lots of that, especially with this meso law. I mean, you have guys from Texas and, you know, Oklahoma advertising. You always tell because they sound like they have brain damage. Then you figure, oh no, they're just from Oklahoma. So you guys ever listen to Mickey Mantle? Well, all right. So the bottom line here is that this type of commercial speech is protected. This dealt with it before television, but it's the same principles.
Yeah, and you know, one thing you should, and some of you may remember, one of the great surprises of my career was when I was clerking my second year of law school in a firm in Hackensack, and I saw a list that they had in the library. For the younger people here, you may not remember it.
Library?
The library. Isn't that funny? As I'm renovating my office, I have big bins coming in, and every book they paid tens of thousands of dollars for over the years, all going into a bin. I couldn't give them away. No one will take them for free, and they all just go onto a compost heap.
Don't you take them to the county jail?
What?
The county jail won't take them?
No,
Wow.
they have more, too many people offer them. They have dozens of books in there,
Wow.
book sets. But what I found fascinating is I came across a list from the Bar Association, and it was the minimum fee schedule. Lawyers were not allowed to ethically charge less than this amount of money for any of the listed services, real estate closings, contracts, wills, etc. There was a minimum fee schedule. Can you say monopoly? And it was unethical for you to charge less than that. Then everyone else would be in competition and they'd have to charge less. You could not ethically, this is 1974, you could not ethically charge less than what the Bar Association set out as the minimum fee. Wow.
Yeah.
And hence the need for this, because when they talk about regulating commercial speech and the fact that it is allowed, one of the factors they cite in one of the cases is that, listen, competition is good. It's good to have people out there competing, because then price levels will find a fair level. When there's fair competition, they'll find a fair level, and the public will benefit by competition. That's the rules behind antitrust. It's the rules prohibiting monopolies. And with respect to attorneys, it encourages attorneys to charge a price that's fair and commensurate with their services. And when you can shop around, the market, the free market, will always determine that.
This case had an inordinately gigantic impact in New Jersey. Okay, you guys know like these letter writer attorneys. You know, they write the letters to everybody. They get the and you know what? When there was one letter writer, that guy made a lot of money. All right, but now you like these defendants, they get 10 letters, 12 letters. You know, I guess they have the tendency to cancel each other. Do your clients ever bring those letters into you, Joey?
They do. And listen, you know, I have to tell you, that's the only way I found out when my daughter got speeding tickets. You know, she said, I hope Dad doesn't find out. And the next day I'd be standing there with a dozen letters. And I remember what I told her once. I said, look it, I said, I went through these letters. I said, if you need representation, I said, you ought to take this guy. He's $99. And I can't do it that inexpensively, so you should go with this guy.
I don't think that's the real danger. I think the real danger is when you get a letter in the mail from one of the municipal courts that has your picture on it from Atlantic City when you were supposed to be at work. And your wife says, what's this?
Oh, yeah.
That ain't me.
What are you talking about?
That's not my car. That's not our license plate. We need to kind of carve out this, Shapiro, because it had such an inordinately important impact in New Jersey. So let's kind of talk about it. Shapiro is a guy who actually tried to do things the right way.
And by the way, that's not misspelled.
No,
that's the way he spelled it.
Right.
That's exactly, you know, it was IRO when he went down. He said, oh, that's not going to fly. Let's spell it with an E. We're down south.
So this is a guy who wants to do things the right way. He asked for an advisory opinion. I think that's a bad idea because you always know they're going to say no. But he went through the motions.
True.
He's like a bankruptcy guy. All right. What his idea is, I'm going to go down to the county courthouse. I'm going to get all the record of all the foreclosure people. Then I'm going to write them all a letter and it says, listen, I can get you a fresh start. I might be able to save your house. I might be able to do this, this, and this. And what he's talking about is, you know, a Chapter 13 type of bankruptcy. And he didn't say anything in there that wasn't true. I mean, everything that he was talking about in terms of fresh start and, you know, maybe save your house and restructure and pay your debts off over a long time. That's what the law says, okay? But he got the opinion from the powers that be, the Kentucky Bar Association, that you can't do that. That it was, you know, you can't utilize the mails to solicit individuals. It has the same impact, especially people who are in crisis in their lives, as in the Ohala case where you're going up and just talking to somebody face to face. It's based, the prohibition is based upon that, okay? Now, you're going to see in about 2 seconds that the Supreme Court says, no, this is going to be commercially protected speech. But that's just the beginning of the story. Take a look. Like print advertising, petitioner's letter and targeted direct mail solicitation generally poses much less risk of overreaching or undue influence than does in-person solicitation. Neither mode of written communication involves coercive force of the personal presence of a trained advocate or the pressure on the potential client for an immediate yes or no answer to the offer of representation. Unlike potential client with the badgering advocate breathing down his neck, I like that. The recipient, Joey, read this, okay? Would you start off with the recipient right here?
Unlike the potential client with a badgering advocate breathing down his neck, the recipient of a letter and the reader of an advertisement can effectively avoid further bombardment of his or her sensibilities simply by averting his or her eyes. A letter, like a printed advertisement, but unlike a lawyer, can readily be put in a drawer to be considered later, ignored, even discarded. In short, both types of written solicitation convey information about legal services by means that are more conducive to reflection and the exercise of choice on the part of the consumer than is personal solicitation by an attorney. Nor does a targeted letter invade the recipient's privacy any more than does a substantively identical letter mailed at large. The invasion, if any, occurs when the lawyer discovers the recipient's legal affairs, not when he confronts the recipient with the discovery.
So, all right, now the cat is out of the bag at this point, okay? Mailing, targeted, direct mail, solicitation to people is a constitutionally protected activity. It's commercial speech. Again, provided that what you say in the communication is truthful and helpful and things of that nature, right? Okay. Well, you know, some little dopey guy doing, you know, Chapter 13 bankruptcy, that's one thing. But, you know, there's a whole lot of ways of practicing law out there, okay? One of which involves personal injury. And sometimes you get these personal injury cases that the people desperately need representation, and they have faced the most unspeakable catastrophe in their life. And that's in Ray Annis. Joey, could you talk about the Annis case for a minute?
Let me tell you right from the outset how the court frames the issue here. The question in this case is whether the commercial speech guarantees of the First Amendment confer on lawyers the right to conduct that clearly offends common decency. And here's the background they begin with. This is the first paragraph of the opinion. The familiar spectacle of lawyers and their agents preying on the victims of disaster has occasioned revulsion and prompted calls for reform. In the aftermath of the tragic release of poison gas at the Union Carbide plant in Bhopal, India, American lawyers rushed to India in an attempt to retain clients, and in their zeal brought shame and discredit to the American bar. The examples of abuse are chilling. They then talk about two examples. I remember this one. In 1987, a plane crashed on takeoff in Detroit, passenger airliner. If you're a pilot, and I used to fly, taking off is always the most dangerous part of the flight for a lot of reasons, but mostly because you have all the fuel on board. You know, when you're landing, the fuel is to some degree exhausted, and fire and smoke are two of the biggest dangers on crash. Now you have a loaded bomb when you're taking off. This plane crashed in Detroit, and the flames, from the jet fuel blazed all around. And what's remarkable about it is that everyone on the flight died, except for a 6-year-old girl who came walking out from among the flames, unharmed, unburned, and just walked out from the middle of the burning wreckage. And she lost her family, but somehow she was invulnerable to this. It's a remarkable story. In that case, those who were grieving and those who came to see if their relatives were okay, and when the airline would get the people together to inform them on the investigation, they wouldn't allow outsiders in. However, they did allow a Catholic priest in to console the people, to tell them that their loved ones were in a better place, that they were in heaven, they found God, to console and to generally help minimize their grief. This priest, of course, wasn't a priest. He was an actor hired by a lawyer, because at the end of his speech, he would give each of these people the lawyer's business card and say, if you want to further console your grief, if you want a sense of justice, hire this man. I know him. He's a good man. He'll help you. He's experienced in these things. This was an actor posing as a Catholic priest. For some reason, the court references this as being reprehensible. I don't know why. And you also have how the first sentence from a letter sent to the mother of a child whose daughter had just recently suffered extensive brain damage. Just recently, in the past few weeks. And the first letter of the first sentence of that letter to this mother, with her daughter lying brain damaged, was, "How much money would you like to get out of this case?" Now, there are certain people who are oversensitive would find that offensive, I guess. 4 months ago, we celebrated is the wrong word. We passed the 25th anniversary of the Lockerbie crash in Scotland. 4 months ago this month, as a matter of fact. December 21st, 1988, terrorists with Gaddafi behind it, blew up a plane over Lockerbie, Scotland, contained many, many students coming back. One of those students was a Mr. Lowenstein from Morristown. And the family, of course, was in terrible grief. It took them, remember, this plane crashed from a very high altitude, it exploded at high altitude, and as a line from an old song goes, you know, it was in pieces on the ground. It took them a while to find and identify the bodies, and the Lowenstein family did not have their son's body identified until January 3rd. That was about 2 weeks after the crash. The day following that, an attorney in New Jersey, Mr. Annis, he sent a letter to the family in which he expressed deep concern for the grief that they must be feeling. But he did say, me and my partner, we're experienced practitioners. We won't charge you. Other lawyers will charge you a full third. We're going to charge you less than a full third. We have a lot of experience doing this kind of thing. And, you know, we won't charge you for the initial consultation. And guess what? Because you're special. If we don't get a recovery, we won't charge you any fees. Whoa, how's that for a PI lawyer? That's the letter that went out. Now, the Supreme Court ultimately made its way to the Supreme Court on the disciplinary matter. And the Supreme Court had to deal with these issues. They dealt with the fact that commercial speech has limitations. Because for all the reasons that Bob has already said. But, you know, one of the main reasons is speech is so important in our society for people to express themselves in the arts. What about political speech? That may be the single most highest protected form of speech. It advances all of our best interests in choosing a government and in having communications with friends and relatives. But commercial speech serves a different purpose, which is to sell a product, and therefore it's out to make a profit, and then we can therefore limit it. In fact, it is said that you can regulate commercial speech unless it can be unregulated so long as it's lawful and it's not misleading. However, if there is a substantial government interest at stake, then it can be regulated. Now, in this case, the substantial government interest was protecting those members of the public who have suffered the ultimate tragedy.
Joey, can I ask you a question, though? Because there's a countervailing issue here. And that is that the Supreme Court has authority to control the conduct of attorneys. They have no authority to control the conduct of insurance adjusters. And there's nothing to prevent them from soliciting these people who are vulnerable and selling them a settlement on the case which is wildly below what the market expectation would be. What are your thoughts on that? Well,
I can tell you that one of the problems is, you know, that we do have a certain international convention that limits damages to major carriers such as airlines that need to be paid under certain circumstances. And it's called, what is it, the Warsaw Compact?
Warsaw Compact.
Yeah, and the Warsaw Compact limits the amount of damages. And the airlines are, and the countervailing argument to plaintiffs' attorneys who bitch and moan about their immediate solicitation of people who are grieving is, hey, the airlines do it. They come running in and they say, hey, we're really sorry, we really care about you. But don't forget, you can't get more than this amount of money. So don't go out hiring any lawyers because that's going to be not to your best benefit. You're guaranteed this maximum amount of money and we'll give you this maximum amount of money, which is pitifully low, tens of thousands of dollars. And of course, when they do say that, the argument is that is false and misleading because the families are not limited to that amount for other reasons. For instance, if the airline was egregiously negligent, or if a parts supplier gave them defective parts, or if there were other airplanes involved or other acts of negligence, or if security at an airport was at fault because a bomber got on board. So there's lots of ways to recover in these kinds of accidents that isn't directly related to the airline, which is protected by the Warsaw Convention, unless it exceeds carelessness and goes to an egregious level. And there is that argument that they come running in and they contact these people right away in even a worse way, saying, ha, you'll get money, but not too much. It's limited to this. Don't sue us and don't bother suing anyone else. And what about out-of-state attorneys? These decisions cover your license as a New Jersey attorney. But out-of-state attorneys come running in, sort of pro hoc vice, and start soliciting people. Now, true, once you come into this state, you are regulated by this. But what are we going to do? Ban you from practicing in New Jersey again if anyone finds out? That's it. So out-of-state attorneys get to swoop in like vultures on these poor people. I mean, any of you who have done personal injury back in the mid-'80s, I used to do a lot of personal injury. And, you know, I'd have clients that I represented for 10 years, people that I loved, and I'd hear that they were involved in a terrible accident, and the daughter would call me up and say, Mom was involved in a terrible accident, would you go see her? And I would go to the hospital to see her, and she said, oh, I already got an attorney. I said, but you were only injured about 6 hours ago. Oh yeah, he came this morning, they were very diligent. That's when I found out that all the nurses in all the hospitals get paid a lot of money to refer people to certain personal injury attorneys. I was, honestly, call me naive, I was stunned. Nurses were making $500 a pop if that lawyer could come in. They would call up the lawyer, they would give the woman or the victim the attorney's card, say he's the only one, he's great, call up the lawyer, and he would come in unasked, and the groundwork was already laid by the nurse, because if he got hired, she gets $200, $300, or $400, or $500 depending on the size of the case. And that's back in $80, okay? So yes, there are insurance companies, there are representatives of the airline, there are out-of-state attorneys. All of that's a problem, and so the personal injury attorneys say, this is unfair to us. Well, what the court said is, look, it's this, and let me just read you what they talk about here. Can the government, let me just get, well, they talk about our industry and they say, look, we're not like everybody else. We're lawyers. We're held to a higher standard. They say the time is long past when we can view the practice of law as the matter of a public trust in which a barrister's fee was but a gratuity for his performance of a public service. That's the way it used to be viewed. The barrister was just doing a public service, and if you wanted to tip him because his public service benefited you, then you could do so. They actually wore a payment pouch on their back because they would not accept payment, and they would turn their back like this, and a person would go up behind them and put money in their pouch in the back. So there was no eye-to-eye contact in a gratuity.
Normally you do that for witnesses now.
However, the court talks about, the changing times, and it says, and they talk about that it's no longer that, where it's only gratuity, but they say, the time has not yet come, however, when we must view the practice of law as akin to the sale of aluminum siding. By the way, my brother used to sell aluminum siding, and my brother was a career con man and scam artist, so I'm particularly sensitive to this. It is not that we think any less of those who are engaged in selling aluminum siding. If they knew my brother, they would change their mind. But we expect the truth of them too. It is simply that we expect much more from attorneys. Now, we talk about, the court talks about the protections that can be afforded it, but they do mention this, and this is what they essentially hold, that the commercial speech guarantees of the First Amendment do not protect attorney conduct that is universally regarded as deplorable and beneath even common decency because of its intrusion upon the special vulnerability and private grief of victims or their families. So what is the special government interest? Is to protect victims. Now, how do you determine whether someone is still so caught up in grief that they cannot make a commercial decision? That's what they're saying. People are asked to make decisions about representation when they're so caught up in grief they can't think straight. And I've seen that a half a dozen times in my life, and people around me where a husband dies and people come running in, attorneys come running in and solicit them for the estate or for a personal injury action. It was abhorrent to me. And what the court said, and look at the lawyer here, Annis, what he said was that how would I know that although I read that his son's body had been identified, so that day I sent him a letter. Seriously, that's what he did.
Joey, may I read the letter, by the way?
Yeah, please.
Dear Mr. Lowenstein, initially, we'd like to extend our deepest sympathy for the loss of your son, Mr. Alexander Lowenstein. We know this must be a very traumatic experience for you, and we hope that you, along with your relatives and friends, can overcome this catastrophe, which has not only affected your family, but has disturbed the world. As you may already realize, you have a legal cause of action against Pan American, among others, for the wrongful death due to the possible negligent security maintenance. If you intend to take any legal recourse, we urge you to consider to retain our firm to prosecute your case. Both my partner, who's his brother, by the way, and myself are experienced practitioner in personal injury field and feel we can obtain a favorable outcome for you against the airline, among other possible defendants. We'd also like to inform you that if you decide to retain our services, you will not be charged any attorney fees unless we collect a settlement or verdict award for you. Before retaining any attorney, it would be worth your while to contact us, since we will substantially reduce our customary one-third fee that most attorneys routinely charge. Please call us to schedule an appointment at your earliest convenience. If you're unable to come to our office, please advise us so we'll have an attorney meet you at a location of your needs. Okay?
Now,
Joe,
here's
how much experience do these guys have in doing airplane crashes?
Okay, not only had they, although they said they did, not only had they never once handled an airplane crash. Neither one was a certified criminal attorney nor a certified civil attorney. Neither one of them had ever tried a case to a jury of any kind, had never tried a case to a judge of any kind, had never tried a personal injury case. Yet they expressed their background as having experience in handling these kinds of matters.
The letter is, the Supreme Court, is so maudlin and so insincere and so insulting.
And so misleading and false. Right. They talk about the standard one-third contingency fee. We all know that there's a sliding scale in contingency fees. I think you're entitled to up to one-third of the first $500,000, and then it's 25% of the next $500,000, and then after $2 million, it's in the discretion of the court. So it's not a standard one-third fee. It's not permitted by our rules. That was an absolute lie. And the fact that they wouldn't charge them a contingency fee if there was no recovery, that's the law of mathematics. One-third of zero is zero. But they made it sound as if they were doing them a favor. The Supreme Court got off on that. But they also said, look, we know that we can go after this person.
Joey, can you read this to everybody here?
We have recognized the attorney's rights to distribute truthful, non-deceptive advertising of their services. Indeed, lawyer advertising may provide alternative avenues of relief to members of the public who are unaware of their legal options available. Even in cases of mass disaster, general public notices in affected regions might serve that end without the offensive intrusiveness of a targeted solicitation. Nothing in the Constitution, however, requires us to countenance solicitation that intrudes upon the victims or in their families in the initial throes of their grief. Their substantial government interest is to protect these people who are otherwise defenseless. In imposing discipline for such conduct, we wish to make it clear that we do not seek to convert into constitutional doctrine some sort of effete etiquette for lawyers, nor even a disguised version of the previously disapproved standard of dignity for attorney advertising. There used to be an ethics rule that your advertising had to be dignified. Those of you who were present when we ran the commercial at the beginning might not call that commercial dignified.
Well, they know that the parts of law and dignity have nothing to do with each other.
Yeah.
Anybody ever been to the Bergen County Jail would know that.
What we are talking about here, as is our concurring member, is conduct that is patently offensive to the common sensibilities of the community because it intrudes upon the private grief of victims or their families, serves only to compound the sorrow, and solicits representation of them at a moment of their extreme vulnerability. It's taking advantage of these people. And they came out with a blanket rule. They said, look, at a minimum, you cannot contact people that are involved in these kinds of terrible disasters for at least 2 weeks after the later of the occurrence of the accident or when their loved ones are finally identified as having been involved in the accident.
Now, this waiting period ultimately was codified in the rules of court and also, by the way, later on in the statutory criminal law at 30 days, okay? So a 30-day cooling off period, so to speak, before you can solicit these individuals through targeted direct solicitation. Now, that had never come up before, and whether or not a cooling off period, a 30-day limitation, was constitutionally permissible was an open question. This was just done by fiat by our Supreme Court. That precise issue was determined in Florida Bar versus Wentfort, short time. What year was Annis, Joe?
Annis was 92.
All right, so this is 1995. This precise issue goes to the United States Supreme Court in the Florida Bar case. Take a look at it. Speech by professionals obviously has many dimensions. There are circumstances in which we will accord speech by attorneys on public issues and matters of legal representation the strongest protections our Constitution has to offer. So that'd be pure First Amendment same level of protection you get for political speech. This case, however, concerns pure commercial advertising, for which we've always reserved a lesser degree of protection under the First Amendment, particularly because the standards and conduct of state licensed lawyers have traditionally been subject to extensive regulation by the states. It is all the more appropriate that we limit our scrutiny of state regulations to a level commensurate with the subordinate position of commercial speech in the scales of First Amendment values. We believe the bar's 30-day restriction on targeted direct mail solicitation of accident victims and their relatives withstands scrutiny under the three-pronged central Hudson test that we've devised for in this context. Remember, we talked about that, the test for commercial speech in the Central Hudson Gas case. The bar has a substantial interest in both protecting injured Floridians from invasive conduct by lawyers and preventing the erosion of confidence in the profession that such repeated invasions have engendered. The bar's proffered study, unrebutted by respondents below, provides evidence indicating that the harm it targets are far from illusory. The palliative devised by the bar to address these harms is narrow, both in scope and duration. Constitution, in our view, requires nothing more. Now, here's the New Jersey side of this, okay? RPC 7.3b4, this comes both out of the Wentford case as well as in re Annis. Here is the RPC. This restriction of communication involves unsolicited direct contact with a prospective client within 30 days after a specific mass disaster event when such contact concerns potential compensation arising out of the event. So that comes directly out of Wentford and out of the Annis case. Okay, that's the RPC. The legislature got involved in this mess. Take a look at this. This is 2C48-5. This is a criminal statute. In addition to any other sanction that may be imposed by the Supreme Court, an attorney who violates the rules of professional conduct, which would be RPC 7.3, by contacting an accident or disaster victim or an accident or disaster victim's relative, usually means other than written communication to solicit professional employment on the attorney's own behalf, who acts with intent to accept money or something of value, shall be guilty of a crime of the third degree. Okay, so not only is it an RPC violation, it is a crime, but notice how much broader the criminal statute is than the RPC. The RPC talks about a specific mass disaster event, okay? Well, people get clobbered and killed and maimed and have their lives destroyed every minute of the day and night in car crashes around the state, and accidents and slip and fall and stuff that happens at work. People get hurt. It's part of life. Okay. Notice that the criminal statute not only deals with disaster victims, but in the alternative, an accident. Okay, so the criminal statute is much broader, which it conceivably could cover people who were just involved in a regular type of a car crash. Now, there was legislation proposed a couple of years ago, and I think it got thrown out because of the Shapiro case, dealing with New Jersey attorneys who were soliciting business from people who were victims of accidents, not for the personal injury case, but to represent them on any tickets they might have received. There was a bill in the Senate to criminalize that type of conduct, and I think it kind of got shot down, probably on advice of the Office of Legislative Services, that it probably ran up against the Shapiro case because it wasn't trying to target them for personal injury work, but rather to protect them on their tickets. We'll see. I don't know that anybody's been prosecuted on this, but you'll see there's a companion statute which not only makes it a crime of the third degree, but requires incarceration on the first offense, notwithstanding the presumption against incarceration. All right. Now, we're going to come back to Annis in a couple of seconds, but I just want everybody to be aware where we stand on this. I want to take a second now and look at just very quickly the rules of court, and I want to start off with the Committee on Advertising, okay? Look at the top of the page there. It says Committee on Attorney Advertising, CAA, formed in 1982. Does everybody see that on that page there? There's a link here that I have for you. I don't know the page numbers. We couldn't afford the ink for that. But it says Part 2, New Jersey Law. Everybody see that? There's a link in your materials right here. Please be aware of that link. It's probably the most important thing in this book. That is the link to the 43 opinions that have been promulgated since 1982 by the Committee on Attorney Advertising. Okay? Their opinions have the force and effect of law, in the sense that the RPC say if you violate an opinion of the CAA, that is an ethics violation and you can be subject to discipline. Now, if you're thinking about doing something and dealing with any type of advertising, you've got to look at their opinions. The CAA will take cases that are submitted to them that are real-life cases. They'll do advisory opinions. From time to time, they'll set standards that the attorneys have to utilize. Many times they reverse themselves or withdraw their own opinions. On occasion, their opinions are vacated by the Supreme Court. And you have to kind of read through all their opinions and the history of their opinions to know what to do. There's only 43 of them. So if you're going to embark on some type of advertising at all, it'd be a good idea if you look at the CAA first and see how they've talked about it so you can conform your conduct to the requirements of the CAA. Let's just look real fast. This is the rule that this is the court rule that actually formulated the CAA in 1942. And remember, their opinions have the force and effect of law. You've got to know them before you embark on some type of advertising. They are required to set the standards for advertising, adopting guidelines, etc., etc. They can do advisory opinions, as you'll see here. Also, they get real live cases as well. Sometimes people file complaints also, and they can rule on them. Okay? All right. Let's get into the RPCs for a couple seconds. 7.1, this deals with communications concerning services, and I showed you this earlier on. And you'll see how this parallels the Supreme Court decisions you've just seen. A lawyer shall not make a false or misleading communication about a lawyer, the lawyer's services, or any matter which the lawyer has or seeks professional involvement, okay? So that is nothing more than a rehash of Bates, which says that this type of speech is not entitled to constitutional protection. Here's the definition of a false or misleading statement. It contains a material misrepresentation of fact or law. Now notice the key here is material. Puffing, a little bit of exaggeration, that's fine as long as it's not material, okay? So for example, you say that you're admitted to practice in Illinois, all right? Well, you're not admitted to practice there. That would be material, especially if somebody was relying on you for an opinion of something out of material.
We have friends on the Supreme Court.
Well, that would be palpably false. Or admits a fact necessary to make a statement considered as a whole not materially false. Number 2, likely to create an unjustified expectation about results the lawyer can achieve, or states or implies that the lawyer can achieve results by means that violate the RPCs. Where you get a lot of this is in personal injury advertising, where the attorney will say, I belong to the $1 Million Club, I'm a super lawyer, I've gotten $10 million worth of recoveries over the last 5 minutes, okay? You can't do that, that would violate this. Now, we got to bring up this nasty topic, we might as well do it now. This particular prohibition puts New Jersey attorneys at a decided disadvantage because it doesn't apply to attorneys that are advertising out of state. So someone who has a practice in Philadelphia and has a practice in New York, they can run any type of garbage they want, putting about, showing money, bundles of cash. This is the amount of money I got just last week for clients, People who are unsophisticated who don't understand this stuff, they jump all over that, where you can't do that in New Jersey because it creates unjustified expectations. For you to say that you got a particular client $1 million is completely meaningless. I mean, that might be a good recovery and it might be a terrible recovery. If the case was worth $10 million and you got the guy $1 million because you were going to let the statute run or something like that, or because you did something stupid on the case, or because you're a bad lawyer, or you settled the case for something that was way undervalued, it creates in the unknowledgeable client all kinds of expectations that are not appropriate. Puts New Jersey attorneys at a distinct disadvantage.
It reminds you of the story of the guy when he gets back from Vegas. His friends ask him how he did. He said, are you kidding? He says, I drove into Vegas in a $5,000 beat-up Chevy. I left in a $100,000 bus.
This next one is particularly aimed at the super lawyer designation. Compares the lawyer services with other lawyer services. Okay, and now if you're going to call yourself a super lawyer, though, you've got to go through this business, and most of the people where they get in trouble is they don't have the disclaimer on the bottom. So if you're going to call yourself a super lawyer, there's 2 ways you can do that. Number 1, you can pay for the honor, all right, which is prohibited here. Or number 2, if there's an actual ranking organization that does it for you, there have to be objective criteria about why they selected you as a super lawyer, all right? And then at the bottom of it, if you're going to use this in a website or some type of advertisement, you've got to have this disclaimer. No aspect of this advertisement has been approved by the Supreme Court of New Jersey.
Most people just put a link because these standards that each of these rating organizations do, super lawyer, best lawyers, whatever.
$1 Million Club is another one.
$1 Million Club. They put they usually just put the link because these firms, understanding this obligation, then list all the standards of how they evaluate whether you're the best lawyer or super lawyer or whatever. So you just put that link and they can go there and they can see what the criteria are to be considered that.
Now on fees, this has particular utility in the internet world when you're doing website advertising, and it really is only relevant when you're dealing with consumer type legal services, bankruptcies, real estate, personal injury to a certain extent, and criminal. Joe, I always tell a story about you when I do this. about the utility of charging consultation fees. Because, if you can say free consultation to everybody in your ad, that's perfectly fine. Of course, you're going to have every stumble bum off the street coming in, and then they come back the next day, I want more consultation. My secretary says, yeah, but, you had your free consultation yesterday. Yeah, but I got more questions I didn't ask yesterday. And then you have, for a while, we charged $50 for consultation, and for some reason we stopped, I forget why. And you charge 300?
$300 to $400, depending.
Okay, but it's the reason you do that is because if they can't afford a $300 or $400, you don't want them.
It's a filter.
They're not going to be able to afford your fees, and you credit them against their fee, right?
That's exactly right. If we charge them $5,000 for a fee and a $300 consultation fee, well, that means there's another $4,700 due later on. It weeds out people that are just coming in to get free legal advice, find out what the situation is, spend an hour of your time, and people who may be genuinely interested in hiring a lawyer, but thought that you would be $500 instead of $5,000, and I can't afford you. Then they get angry at you. How dare you charge those fees? I mean, did you ever get that over the phone? People yelling at you that, how dare you? Who, you think you're worth that kind of money? Yeah.
The paradox, though, for Joe is that the higher he raises his fees, the more people want him. What's that all about?
Yeah, that's the psychology of selling. I mean, if you charge lesser fees, people think you're a lesser attorney.
Well, that's probably why I'm bankrupt. All right, so a statement of...
Morally bankrupt, that's different.
A statement of the fee for initial consultations, I say it's okay. You can put it down there. None, 50, 300, whatever. Statement of a fixed or contingent fee for a specific legal service, which is fine, especially in the personal injury context. My feeling is you should always just print what the court rule says in your ad. You can't go wrong by putting in the court rule. Statement of the range of fees for specific legal services. Also, you should designate if you have different fees that the partner is going to charge X, the associate Y, secretary time is Z. You should put all that in the ad as well. Statement of hourly rates, the same thing. Availability of credit arrangements, the best thing for you to do on that, and this is not ethics, it's just practical. Just put in the credit cards, pictures of MasterCard, Visa. You take credit cards at your place, right?
We do.
Yeah. American Express.
So do our clients. That's what they do. They take credit cards.
But list all the credit cards in your advertisement, and that'll take care of that. And a statement of fees charged for qualified legal assistance. You don't have to worry about that. That really is not. You wouldn't get that in the private practice. Here's what I just told you. This would be the violation. It would be 7.1b would be the RPC violation. It's unethical for a lawyer to use an advertisement or other related communication known to have been disapproved by the Committee on Attorney Advertising or one substantially the same as one disapproved unless it's been modified by the court or withdrawn, et cetera, et cetera. So if you do this, if the CAA says don't do this and you go out and do it anyway, you get yourself jammed up. The key is whether or not this is strict liability or it actually requires knowing. My sense is that they're just going to assume that everybody's responsible for knowing what the CAA says. That's why I gave you this link, because their opinions are very hard to find. They're not published anyplace. You can only get them online. So look them up. You have access to them now. You don't have to, hunt around for them. That's why I have that link in there. Very important.
Bob, what about the defense that, you didn't really read your advertisement. You had a reputable advertising firm put it together, and you can't be responsible for what they put together?
Yeah, that's the hydraulic case. I think I might have a reference in here to that. That's a very recent case. It's the most recent pronouncement by the New Jersey Supreme Court on advertising. This is a guy who had a website up, and the website was perfectly fine. He just didn't pay attention to it for a few years, and his brother-in-law, who was the site designer, decided he would make some enhancements to the site and put in there that the hydraulic was a certified civil trial attorney, which is very impressive, except that he wasn't. All right, so his defense was, I didn't know what this guy did. I don't pay attention. The Supreme Court gave him a pass, primarily because I think they believed him, and number two, this is the first time they commented on this, but they put in their opinion some very, very strong language making us as attorneys responsible for monitoring the content of our websites to make sure that we're responsible, we're strictly liable for what's on there. And it's not only for websites, for all types of advertising. You ultimately are responsible for what you're disseminating to the public, be it on television, internet, direct targeted mail, newspaper, whatever it may be. The medium doesn't matter. The message matters. All right?
One of the mistakes that one firm made in the state was they put, hire certified civil attorneys. They're the best able to represent you. That's us. Well, yeah, the 2 senior partners were, and one of their associates, but 5 other attorneys in the firm weren't. The ad mistakenly gave the impression that everybody in the firm was a certified civil attorney, and then obviously the way around that is simply to designate after each person's name, simply say, you know, many of our attorneys are certified, and then list them and which ones are and which ones aren't.
Here is 7.2, which is the actual RPC dealing with advertising. Now, this first part comes directly out of the Feldmeister and Isaacs case, which I think is from 1986. This is a decision that was written by the Chief Justice. And, you know, remember, he had some very, very strong beliefs, and they weren't limited to drunk driving, as you recall. And because of this just little personal predilection he had about the way lawyers should conduct themselves, and he admits in the opinion, listen, I come from an era when attorneys didn't advertise at all. It was prohibited. It's hard for us to kind of, for those of us who grew up in that era, to kind of get it through our minds that advertising is okay. So what we're left with to this day are prohibitions that were put in by this thought process by our Chief Justice from almost 30 years ago. Take a look. This is 7.2a. A lawyer may advertise services through public media, such as telephone directory, legal directory, newspaper, other periodical, radio, television, internet, which has been added because there was no internet 30 years ago, or other electronic media, or through mailed written communication. Now, you've seen all the underlying Supreme Court cases that make these types of advertising media legal. Okay, you can do it. The rule just, you know, the RPC just repeats that. Take a look at this, though. All advertisements shall be predominantly informational. That comes out of Feldmeister and Isaacs. They dropped the fact that the advertising has to be dignified. That got dropped in the case, and they substituted that it has to be primarily informational. No drawings, animation, dramatizations, music, or lyrics shall be used in connection with television advertising. This is the most important component of this RPC. It's verbatim taken out of the Feldmeister and Isaacs case. This is strictly coming out of the mind of the Chief Justice. Okay? My own sense is that the time has long come on constitutional grounds to get rid of this. And listen, I have to tell you guys, you know, all of you know me in here as a lawyer. You know, you would have no reason to know me otherwise, but I'm not really, that's not my primary thing in life. Tell them what I do, Joey.
Marketing.
I'm a marketing guy. I produce television commercials. I've done hundreds of them. I've won awards for doing television commercials. I'm a marketer. That's what I do.
You've got to see some of his commercials for his firm. Oh, are they creative?
Well, when you're doing a television commercial, music is so critically important. You saw how the power of the music in that Jamie Casino ad, how that was driving the energy behind it. Music sets moods, it creates energy. It's from a First Amendment standpoint, from an artistic standpoint, it's an indispensable component of advertising. But technically, if you use, you know, music in a television commercial, you're violating this particular RPC. And the problem is, there's another Feldmeister and Isaacs case, an earlier one, where they decided they were going to advertise on radio, okay, which was prohibited at the time. So they just, rather than go through the process, you know, filing a lawsuit or asking for an advisory opinion or something like that, you know, declaratory judgment, they just did it and said, we don't care, we think we're protected constitutionally, if you're going to discipline us, go ahead. So that's what happened. And the Supreme Court really blasted them, saying, you know, we set a rule. If you disagree with it, there are mechanisms for challenging our rule on constitutional grounds. File a lawsuit, ask for a declaratory judgment, ask for an advisory opinion. I mean, all these things are in play. Write us a letter and ask us to reconsider it. But no, you didn't do that. You decided that you would purposefully go forward and break our law and then come back and defend yourself on constitutional grounds. You may have a good constitutional defense, but your procedure is what's going to get you reprimanded here. So, I mean, the Supreme Court really sent out the first message in the first Feldmeister-Isaacs case that they expect people to play by the rules and go through the system if you're going to challenge something you're unhappy with. What's the name of the guy who's the Bergen County guy? Vinny. What's Vinny August, right? What's his real name?
Sakari.
All right. Vince, you guys know Vince, right? Yeah. All right. One of the things that I always stress about Vince when we talk about, I should remember the guy's name, I'm going to talk about his case, that he played the game, and he lost, but he played the game absolutely perfectly. He went through the steps every inch of the way. He never violated any rules. He went through the procedural steps, appealing it and arguing it and briefing it, and, you know, he had his day in court. So, I mean, he didn't violate any ethical prescripts at all. It was just at the end of the day, they just said, you got to make a choice, and he made his choice. I hope he makes a lot of money. I hope he's very successul. But the thing that I always admire about him is that he played the game by the rules, exactly the opposite of what happened initially in the first Feldmeister Isaacs case.
Well, you do know one of the sequelae to that case is that because it was a First Amendment case, free speech case, Playboy, which has a long history of, showing naked women, but also is a very big First Amendment rights advocate over the decades, ran an article on his case and his cause, and it made Playboy online. And it does have the, you may call it fortunate or unfortunate consequence, that Judge McGady is now mentioned in Playboy magazine.
The RPC goes on to say the following: no advertisement shall in any way rely on techniques to obtain attention that depend upon absurdity or demonstrate a clear and intentional lack of relevance to the selection of counsel. Now go back to the Jamie Casino ad. Could you make a case that dealt with absurdity, or it was an appeal to base emotion in order to attract clients? Had nothing to do being predominantly informational. Wasn't informational at all. It was effective advertising. It tells a story. It attracts your attention. When you're putting an ad together, you remember AIDA, AIDA, get their attention. That's the first thing. Number two, attract their interest. Get them interested in what you have to say. Number three, get them to make a decision. And number four, get them to take action. Call now. Call the next 5 minutes, that type of thing. That's what he was attempting to do in that ad. That has nothing to do with the Supreme Court's decision that these things be predominantly informational. Okay, you got to attract people's attention and get them all stirred up. You're dealing with apples and oranges here.
Well, what was offensive about that commercial is that he said he no longer represents the villains. Hey, those are alleged villains, buddy. I do this kind of work.
No, he was only doing PCR. It's kind of funny when I think about this. The best way I can, we get these hot button political topics. One of which is in play right now is the minimum wage. Okay, they want to raise the minimum wage to, I don't know what, $25 an hour or something. I don't know what it is.
$10. Right?
Whatever. Okay. $10.50. Okay. Where'd they get that number? They made it up. Okay, it's a number. So you have politics, and then you have economics. These are two different scientific pursuits, and you have arguments politically for raising it, and you have arguments against doing it from an economic standpoint. And the idea here is they have nothing to do with each other, okay? Economics has nothing to do with politics, and politics has nothing to do with economics. These are two different sciences that run by independent rules with each other. The problem that people run into is when they try to logically link the two of them, and they have nothing to do with each other. Same thing here. These RPCs have nothing to do with the reality of attracting an audience or persuading people, getting them to take action, become clients or whatever it is, sell them soap or sign up for the army or whatever it may be. They have nothing to do with each other. You've got to attract people's attention, get their interest, get them to make decisions, get them to take action. It's hard to do that when you can't use music, animation, drawings, lyrics, and have to have stuff that's primarily informational, okay? But the court goes on to say, can't rely on techniques to obtain attention that is based upon absurdity or demonstrates a clear and intentional lack of relevance to the selection of counsel. Included in this category are all advertisements that contain any extreme portrayal of counsel exhibiting characteristics clearly unrelated to legal competence. Again, go back to that Jamie commercial and ask yourself whether or not that would violate this RPC. You got to save all the copies for 3 years, no big deal there. This next part just really deals with the cost of advertising, because you don't want to get yourself in a situation where you're alleged to be splitting fees with lay people. So you can pay for the reasonable cost of advertising, and this has been expanded by CAA to include pay-per-click, combines you get involved with on the internet where you're sharing, you're paying for different territories and things like that. No problem there. Personal contact with prospective clients. Remember, this is going to come out of the Annis case as well as the Ohalik case that we talked about earlier, dealing with your ability to communicate with people face to face. Okay, so you can't send a written communication to a prospective client if, and then you see right here, knowing the person should know the physical, emotional, mental state of the person, such that you couldn't exercise reasonable judgment. All this other stuff is just a straight out of the Annis case, okay, and the Wentworth decision by the Supreme Court. Okay. Now this next part deals with advertisements that you're sending to individuals that have disclaimers. Okay. So here's number 5. Let's just take a look at it again. This is the kind of the New Jersey version of Shapiro and the limitations on targeted mail for the letter writers, all right? Communication involves unsolicited direct communication with a prospective client concerning a specific event, getting a traffic ticket, Joe's daughter. When such content has pecuniary gain a significant motive, except the lawyer may send a letter by mail to a prospective client in such circumstance, provided that the letter, and I'll give you an example of this in a moment, bears the word advertisement prominently displayed in capital letters at the top of the first page of the text and on the outside of the envelope. Now, the lawyer I'm going to show you actually uses a window envelope, so when he folds his letter, the word advertisement can be seen through the window. Unless the lawyer has family or close personal people, contains the following notice at the bottom of the last page of text. Before making your choice of attorney, you should give this matter careful thought. Selection of attorney is an important decision, all right? And contains additional notice at the bottom saying that if this is inaccurate or misleading, write to the Committee on Advertising. Okay? All right. You'll see an example of that in a moment. Here's fields of practice we talked about previously, and you saw this in the RLM case. Lawyer may not state or imply that the lawyer has been recognized as certified or specialist in the field of law, except as provided here. And they've recently added they're going to be certified municipal court trial attorneys as well. The Hydrilli case is the main case. We talked about that a few moments ago. Here's Feldmeister and Isaac. The first case here in Ray Feldmeister, this dealt with the radio advertising I told you about a moment ago, and they just decided they would do it rather than go through the channels. They learned their lesson in 1986, came back. Here's the decision by the Chief Justice, and I've alluded to this. Just want to take a look at the language here. Despite the foregoing, we've decided to continue the more substantial restrictions on television advertising. There's no doubt that the potential impact of irrational factors is greatest in that medium. Furthermore, the group that has the least access to informed sources on attorney skills might rely most heavily on television for information. The less affluent, the less educated public is the most vulnerable to this kind of ad. This is all, there's no basis for this except this is his opinion. He's the Chief Justice. He gets to say this kind of stuff. The other side of the coin is that such restrictions will impair the effectiveness of the ad and perhaps thereby reduce some benefit that the attorney advertising might have for this income group, who needs information about legal services that are greater than other groups. We continue the restriction in the case of television advertising subject to future evaluation provided for in this opinion. Maybe the time has come for somebody to do something about this. It's not going to be me, but somebody. We will learn through time and experience about the effectiveness and ineffectiveness of attorney advertising without emotional appeal, as well as their potential for harm. Well, the Jamie Casino ad was 100% appeal to appeal based upon emotion. Our conclusion is ultimately based on the belief that the risk may be substantial and that our duty is to protect the public against it. We believe that whatever loss there may be, an effectiveness is worth the advantage of protecting the public from that risk during the trial period. And this trial period began in 1986, all right? Here's the Annis case, which we've already talked about. Team law is the kind of the next iteration of attorney overreaching. This dealt with something in Edison, New Jersey. Remember this case, Joe, where like some big gas thing blew up the whole neighborhood? And hundreds of people apparently were displaced as a result of this explosion. So lawyers descended on it like vultures, and this team law set up a kind of like a trailer or a tent or something and a big sign outside saying team law. And their whole idea was to get people to come to them and sign them up. So they weren't really directly soliciting them. They were just making themselves very prominently available. They all wound up getting reprimanded. And you can see here the evils of in-person solicitation for pecuniary gain after an accident extend beyond intrusion upon private grief. Such solicitation invites an opportunity for fraud, undue influence, intimidation, overreaching, and other forms of vexatious conduct. In-person solicitation may exert pressure and often demands an immediate response without providing opportunity for comparison or reflection. Okay? The bottom line is all the guys who got involved with this wound up getting reprimanded, and it's just really kind of the next step, one step removed from personally soliciting somebody who had been involved in a catastrophe. All right? Here's Hydrilli, I mentioned a few moments ago, and I said they gave this guy a pass primarily because they felt he didn't know, but they set the standard here pretty high, okay? Whether a website is created by an outside consultant or developed or maintained by the attorney and his staff, all language design that appears on it should be reviewed frequently for compliance with Rule 139 and all the rules of professional conduct. You have an affirmative obligation to monitor. They say earlier in the opinion, not only this, but all advertising, okay? Okay. Here's actually the statement. No attorney who's not complied with the requirements of 139, which is the trial certification, should display the New Jersey Supreme Court certified seal on a website and other advertising on letterhead or in any other form of communication or otherwise state or imply that she has not been certified. Okay? Here's the key. This is the sentence I was looking for. Notwithstanding our decision on the record of this case, we remind the bar, that's all of yous, we remind the bar that attorneys are responsible for monitoring the contents of all communications with the public, including their websites, to ensure those communications conform at all times with the RPCs. This is a strict liability type situation. You have the responsibility for making sure all the stuff you're utilizing, especially in the advertising vein, complies with the RPCs as well as remember the opinions of the CAA, which really become as an adjunct to the RPCs. All right, I want to take a look at a couple of advertising examples, starting off with direct mail. Yeah, this is I Defend You. Joey and I know this guy very, very well. He's a very, very savvy lawyer, businessman, and promoter, and not obnoxious about it at all. But you can see here, I'm just showing you how he complies with the RPC here. So his word advertisement is written in capital letters. He does not have it on the outside of his envelope because when you fold this, the address and the advertisement are in the window, so he gets around it that way. He has the required language in here, and if you're going to do a targeted solicitation, just copy what he has in here in terms of the language on the bottom, the language in the body of the communication. Okay, I've got two examples of a newspaper ad here that I want you to take a look at. This is KMH&L Attorneys. Notice their website, www.kmhlawyers.com. Okay, now I know all these guys. A couple of them I'm very friendly with, so I'm going to kind of temper what I'm going to say here. But there's all kinds of things going on here I want to tell everybody about. Number one, website names, domain names. You all know that the name of your law firm has to include in it the name of one or more responsible partners, okay? You can't call yourself Maywood Legal Services or something like that. You know, you've got to have the names, you know, REM Law Group, okay?
Well, there's no responsible partner in that one.
That's the rule. The rules of court require that, okay? But that does not apply to website advertising. You can select any domain name you want for your website. That's number one. And number two, you can advertise fully and completely utilizing your domain's website, okay? Now, the only prohibition on this, and you'll see this is all coming through CAA opinions, you've got to have a name and street address inside the ad. So if you're going to have a website that's going to be, you know, greatlawyer.com or something like that, all right? That's perfectly fine. You can use that. You can market yourself with that domain name. That's perfectly great. But in the body of the website, you've got to have the responsible people and a street address so they can tie that domain name to you. That's very, very minor. The key is to utilize a really sharp domain name is an indispensably important component of marketing. I was thinking one the other night, because you never want your clients to forget who you are. You always want them to remember, okay? The other day, you got to correct me on this. We went online, just had a thought. Let's go on GoDaddy.com. I want to buy a thing. I don't want my clients to forget about me. I'm going to buy the domain name bobwasmylawyer.com. I could have gotten that for $13 the other day, okay? I mean, this is the type of stuff you want to do. You never want your clients to be able to forget you so they can find you or they can tell friends, you know, about the great result you got. And if you want to get a hold of this guy, go to bobwasmylawyer.com, you know,
Bob,
make an appointment.
I tried to get the domain name I'llGetYouOff.com. Turned out it was taken by an escort service, so it wasn't available.
So my first criticism of this advertisement, now notice they followed all the rules for attorney advertising. They have a street address. That's one of the things you've got to have in there. You must have a street address in your newspaper advertisement. And by the way, there's a CAA opinion that requires the same thing on billboards. You've got to have a street address in there as well. As I told you a moment ago, you've got to have the name and street address in the internet ad. Now notice at the top here, they have a terrible domain name. Number two, I know all these guys. These guys are my friends, they're colleagues, they're in my county. Who are these people? I don't know. They don't have their names there. This is a business of relationships, okay? Put your names who's here so you can say, oh yeah, I know that guy. That's Mike. You know, I represented him, or he represented me. They should have their names here. And as I say, they have a terrible domain name. You know, KMH Lawyers. Who's going to remember that? Nobody. I couldn't even remember it. It's right in front of me here. So, I mean, they're running a full-page ad. It's perfectly fine. I guess they're doing okay because they keep running the full-page ad. Not running because they're losing money. I guess people are responding to it. It just, I think there's a whole bunch of stuff they could do to improve this. And remember this concept of leverage. They leverage the newspaper ad to the internet, or leverage the internet to the newspaper ad. You can do it back and forth. They have a mutually reinforcing effect. In the guy, I Defend You, his leverage basically is the target direct mail solicitation goes out, and it refers to the internet. The people come to him, and he'll say, how did you come to this? Oh, I saw you on the internet, and I got a letter. Or I got a letter and saw you on the internet. They have a mutually reinforcing effect on each other. Another little ad, this is one I was running for my law firm, and it's very, very simple. It's a much smaller ad, and again, it's just to kind of attract attention, showing people in handcuffs. And this is what we do, DWI revoke traffic tickets. We will help you. Here's our number, call us, okay? I'm pulling this out because I don't want to practice law anymore because it's terrible, horrible way to make a living. All right, it just is. No, you can do this in newspaper.
Not
Okay.
on TV.
Not on TV. Okay? All right. What I want to do now is take a few minutes and look at some television advertising. And what I want to do is have a discussion among us to see to what extent, in your opinions, these ads comport with New Jersey law or protected speech as per the New Jersey Supreme Court decisions and the United States Supreme Court decisions we've been talking about. Okay? And we'll analyze them. Be mindful then. Well, there's two things going on here. Lawyers in New Jersey have two huge barriers that they have to overcome. The first, of course, is that our RPCs and CAA opinions put us at a self-imposed disadvantage when competing with major media center advertising out of New York City and out of Philadelphia, okay? That's just the way things are, and it costs attorneys in New Jersey clients and money. The second thing, though, deals, and this is a much more pernicious outcome, is for attorneys involved in personal injury, plaintiffs' work, okay? And, you know, so many in our county they're crying the blues, they can't get cases, their business is off, and when the cases come in, there's nothing there for them, especially in automobile. What's going on here? Well, take a look at the Gecko. All right, the Geico Gecko, which is on 24 hours a day, 7 days a week. You can't throw a dead cat without hitting a gecko, okay? What are they saying to the consumers? What are they really telling them? We'll save you 50% on your automobile insurance. Okay, that sounds great. What the people are getting is an utter, total ripoff of every penny they have in their pockets. They are buying the minimum amount of insurance and paying the maximum amount for the minimum amount of coverage, okay? So they get some horrible accident, all of a sudden it turns out they only have $10,000 worth of PIP, or no PIP at all. They have just very, very tiny amounts of coverage. I mean, these days you can get policies that don't even have, they're not even 15 policies, they're less than that, you know? These are just bare bones policies. So people get clobbered, there's nothing there. There's nothing for the plaintiff's bar to go after. There's nothing to deal with, okay? But yet this is the advertising track that has been taken by the insurance companies. Now I'm going to show you some commercials that deal with this too, this is much more harmful to the plaintiff's bar than anything else. You'll see a couple of examples of people who, for getting car insurance, plunk $20 down and you'll be street legal. $20 is all you have to do, and we'll give you an insurance policy. Can you imagine the level of coverage you're getting for $20? Okay? But I digress.
A tradition began at the law offices of Stark & Stark over 80 years ago.
It's a tradition of bringing legal help and compassion to injured people throughout New Jersey and Pennsylvania when they've been hurt and need help the most.
With over 115 experienced lawyers in 7 convenient locations, you know you'll get the personalized and professional attention you need and deserve.
Stark & Stark. Here for you since 1933. Call Stark & Stark at 1-800-INJURED.
All right, stop it for a second. He had music in it, okay? Can't have music. The sad thing is, I've represented every one of those people or their families in that ad. I'm not saying that's anything to be proud of, but it's true. I mean, I know all those people, every one of them. The ad does not appeal to emotion. It's just kind of a straight out, kind of a bland ad to play on their experience. The people coming through there appear to be nice people and competent people and things of that nature. This is more institutional advertising to get their name Stark & Stark out there, which already has a really good cachet. It's a good brand in our part of the state, people associated with personal injury, and they ring the bell a lot. I mean, they're just a very high-end firm in our county. They don't have the maximum number of PI files. I think there's a kind of a low-end firm that will take anything that walks in off the street. Did you realize that when there's a bus accident, like there's always like 100 victims in the bus accident? Did you ever notice that?
Even on a bus that only holds 35 people?
Yeah, that's the weird thing. And they all wind up at this one particular firm for some reason, all right? Let me just tell you something about Stark & Stark, all right? I mean, I just know these people. They're by my county. They actually have a whole marketing department that does this stuff. They're the only firm I've ever seen where they have super lawyer designation. They actually have the disclaimer that's required by the rules of court in their super lawyer, portion for each one of the attorneys who's a super lawyer. So I mean, this is the most ethical firm you can imagine. This is just, they just don't know, okay? Let's take a look at some different examples of advertising, okay? I hold Stark & Stark was pretty high, notwithstanding the music.
Injury victims, you have rights. The right to money, to medical care, to lost wages, the right to insurance money, to cash awards, to damages, the right to legal payback. To enforce all your rights, call me at 1-800-624-8888. I'm Alan Rothenberg, the injury lawyer. I'll enforce your most important right, the right to money. Call me right away, 1-800-624-8888.
Next,
what constitutional amendment gives you the right to money? Was that the 11th?
Yeah. All right, let's look at this other ad. I think this might be coming out of the Philadelphia market. Let's see.
Accidents happen, and when they do, you need me. I am Alan Rothenberg, the injury lawyer. I will strive to protect all your rights and fight the big insurance companies to get you all the money you deserve. I've gotten hundreds of millions of dollars for thousands of clients. I can and I will get you money, or you pay me no legal fee. 1-800-624-8888. 1-800-624-8888.
So that one is a little bit more toned down. That's again coming out of the New York market, but he advertises in the Philadelphia market as well. So he's getting, dealing with situations that are not primarily informational. He's appealing to greed and things that have nothing to do with the selection of an attorney. The whole idea here is to give people unrealistic expectations in terms of what they can hope to get out of utilizing his services, all right? Now, there's a whole bunch of people who will be persuaded by this, okay? If you're a New Jersey attorney, you're playing by the rules, it's very difficult to compete against a guy like this, okay?
A doctor or hospital mistake can be devastating. Let me find out what went wrong. I go after all those that hurt you. You pay no legal fee unless I get you money. I am Alan Rothenberg. I am the injury lawyer. 1-800-624-8888.
There's a 15-second one coming out of the New York market. What do you have next?
I was injured. There was a lot at stake.
I called Rand Spear.
No charge to call them.
They started working for me.
Fast.
A real law firm with people I could talk to.
No charge.
Call Rand Spear, the accident lawyer. 1-800-90-LEGAL. Right now.
This guy's in like 5,000 commercials, all right? He's in the Geico commercial. He's in like something where like you have low T. Then he has another one where some other disease that he has. He's all over the place, this guy. He's an actor. He's nobody. He's not a lawyer. Of course, it doesn't say that on the screen here. Why do they have all black people here? What's that all about? What do you think? They're targeting a market. They're trying to go after people that they perceive as being unsophisticated, poor, not knowledgeable. That's what they're trying to go after. And of course, the offices are in Trenton, Atlantic City, and Philadelphia. They're looking for people who, they think they're going to cash in on some type of. This is a low-end type of marketing, okay? It's kind of obvious what they're intending here. And he said, but you see any problem here with this ad? I didn't hear any music in there. Nothing false or defamatory in there? They should say that he's not Rand Spear, that he's, he's an actor. Probably should put that in there. Okay, no legal fees until you win or your case settles.
Attention liver damage victims. Pain reliever medicines containing acetaminophen, most notably Tylenol, have been linked to liver failure. If you or a loved one have taken Tylenol or prescription painkillers which contain acetaminophen and were hospitalized for liver failure, received a liver transplant, or even died due to complications from liver failure, call the Reliant Group. You may be entitled to a significant cash award. Call the Reliant Group right now to be connected with an experienced attorney for a free consultation and to see if you may qualify for financial compensation. There's absolutely no risk on your part. You don't owe us a penny unless we're successful. Do not delay. There are time deadlines to file a claim. If you or a loved one have been hospitalized for liver failure after taking Tylenol or other drugs containing acetaminophen, call the Reliant Group.
And to the extent that they have any type of disclaimer at all, is completely illegible and tiny and intended to be that way. Plus, it's on the very last couple of frames here, so there's no possible way of any human being being able to read it. So this is being run in New Jersey. There's no street address. There's not even a name of a law firm here. So this could be a consortium of lawyers in Texas or something like that. Since these are national type of mass tort litigation, the venue could be any place. What they're doing is trying to create a market. They're making a market. They're drumming up demand, stirring up trouble, as they said in one of the Supreme Court decisions. You could not get away with this if you were a New Jersey-based law firm, because it violates so many of our rules. No street address, no name, no recognition here, the use of music, all these other RPCs. But it doesn't matter, because these people are from Texas. They're running this out of some other, they could run it actually in any place in New Jersey. I think they're running this out of the Philadelphia market. Hold that for a second. How can you go wrong with a name like Rottenstein, okay? You just can't. Now notice that this one is going to undertake a news broadcast. They're trying to get you to think that this is some type of breaking news like on CNN, okay?
Wait a minute, is this the Malaysian airline again? I'm sick of the breaking news on that.
Well, let's see.
Hi, I'm Erin Bodine, and this is your latest vaginal mesh news update from the Rotlaw News Desk. On February 28th, a jury in New Jersey Superior Court found Johnson & Johnson liable for $7.76 million in punitive damages in a trial for a lawsuit over its Ethicon subsidiary's Gynacare ProLift vaginal mesh, according to sources inside the court. Plaintiff Linda Gross, 47, was awarded $3.35 million in compensatory damages earlier this week after the jury found that Johnson & Johnson failed to warn her doctor of the potential dangers of the mesh. She underwent more than a dozen surgeries to address pain and mesh erosion, scar tissue, inflammation, and neurologic compromise to structures and tissue. For more information on transvaginal mesh lawsuits, visit www.vaginalmeshlawsuitcenter.us.
Wapner Newman.
My husband's been hurt. We need a good lawyer.
What happens next can make all the difference. When your future's hanging in the balance, you need Wapner Newman, Philadelphia's most experienced team for personal injury, medical malpractice, and wrongful death.
Thank you. I knew I made the right call.
For over 35 years, they've been winning for you. Make the right call. Call 1-844-WAPNER1 today or visit us at winwithwapner.com.
Did you guys hear the angels there in heaven? This is like music God is sending down.
It makes me feel bad that I'm not injured. I really.
All right, on the vaginal mesh thing, this would be totally blopped up in New Jersey. I mean, this phony way of presenting this as a news story. Now, everything she said was factually true in terms of the outcome of this case. The idea is, but it creates an unrealistic idea that you can get money out of this, because just because this woman got $7.2 million, that doesn't mean that your case has any value at all. It may be worth nothing. It may be worth 3 times that. Who knows? You can't judge these cases, think that you're going to get the same or similar outcome. That's the problem with this type of advertising. On the Wapner Newman, again, this is a Philadelphia-based firm. The music is intended to make you think that this is actually literally coming from God, all right? And these are people with have power and, you know, well, it is what it is. But again, look at the disadvantage it puts New Jersey attorneys at, okay?
Attention, this is a legal alert for former patients of Dr. Nikita Levy at Johns Hopkins Hospital's East Baltimore Medical Center.
Johns Hopkins Hospital and law enforcement are investigating the unauthorized photographing and videotaping of certain patients who were treated by Dr. Nikita Levy since 1988. If you were treated by Dr. Nikita Levy, your privacy may have been violated. Call Science and Kirk right now at 1-800-522-0102. That's 1-800-522-0102.
You may be entitled to.
It's like the case in Fairfield, Joey.
It's what?
It's like the case in Fairfield. You know where they put the cameras in the bathroom? Yeah. All right. So again, this is another one of these making a market type situations. Guys in Baltimore, he might have been. Johns Hopkins treats people from all over the world, so you know who knows.
Can you imagine if you're this doctor and you wake up one day and there's commercials on TV saying, "If you were this doctor's patient, call us." Oh man, that's just like a bad day.
We got to send that. We got to send that ad down to my brother. Now let's see another one.
I'm Terry Crouppen. I'm a lawyer. I fix problems, your problems. Think of my law firm Brown & Crouppen as a sophisticated legal weapon you can use to make sure your rights will be protected and respected. Look, Brown & Crouppen has collected over $1/3 billion for injured people, not million, billion. See, I fix problems. Call now for free at 421-HELP.
Now look where he is. He's in. He's all over the place. In Illinois, St. Louis. You know, he's a Midwest guy. But the point I'm trying to make here is you can see how this concept of I've collected $1/3 billion, that's going to be objectionable in New Jersey. I'll get him disciplined here. Not only that, plus the use of the music. You can't have a television commercial without music. I'm sorry, you just can't. It's wasting your time. All right. But by the way, this is one of the arguments you can make before the Supreme Court. Every commercial on television everywhere in the United States uses music except in New Jersey. You know, has the rest of the country fallen apart? Well, actually, that's a bad thing to say because it has. But I mean, has anybody been harmed by the use of music? It's so common now. There's no point in prohibiting it anymore.
Have you been denied Social Security benefits that you've worked for? Benefits that you may deserve, that are needed now. If you have been denied, there is hope if you call now. Speak to a disability lawyer in confidence. The call is free. You need to call someone with experience in getting benefits for those that deserve them. Tell them you mean business. Call Rand Spear, the accident lawyer, at 1-800-90-LEGAL.
Notice no music in that one. Why? Playing in New Jersey. Cherry Hill, Trenton, Atlantic City. That's why.
Are they allowed to use an actor?
He doesn't. Well, they don't. You could make the call on that, but you know, he should have. This is an actor, not a regular lawyer. Can we see a couple of those insurance commercials? They're up next. Okay, let's take a look at this, guys.
Don't slam the door. Jeez. No respect. After I get the guy car insurance for next to nothing. I said just pay what you need to be legal. Get good to go auto insurance and get the minimum. That's me. Minimum. He was paying for way more car insurance than he needed and whining because it cost too much. Dude, with good to go auto insurance, you buy the minimum and you pay less and you pay monthly. This car insurance is cheap. Just $20 can get you started. Check it out. Call or visit goodtogo.com and get a rate quote on the spot. We won't ask you your life story, just a few things like your name, address, birthday. Get a cheap rate and a low monthly payment that's guaranteed for a full year. And you're good to go. You're good to go.
Good to Go Auto Insurance. Drive legal for as little as $20 down. Call 1-888-200-9198 or visit goodtogo.com today. That's 1-888-200-9198 or goodtogo.com.
Should actually be not only offended but angry at this. It is an utter and total ripoff of the public. Not telling them that they're paying the maximum amount of money for the minimum amount of coverage. And it just is going to make their lives catastrophic when that day inevitably comes that they're involved in some type of a traffic accident. Okay, it's just totally offensive to me. It's so harmful to the public, and yet there's nothing that we can do about it as lawyers. Nothing. I mean, just can't do it. And the legislature is involved with this because of, these insurance lobbies have tremendous amounts of power. They're able to get these 1530 policy fine, but they have these other things that are less. I mean, how much coverage do you think you get for $1 a day policy, guys?
Beating the high cost of auto insurance is a slam dunk with the General. Just log on to thegeneral.com or call us for a super fast quote. All it takes is a couple of minutes. You'll get a low rate, low monthly payment, and a down payment as low as $59. You'll also get instant online proof of insurance.
Show off. For a great low rate you can get online, go to the General and save some time.
Is this what happens when you get caught driving without car insurance? No, but considering the fines and penalties, it sure feels that way. 1-800-SAFE-AUTO. State minimum coverage, maximum savings.
How many of my clients that get caught driving without insurance, given the choice of punishments, lose your license for 6 months, $1,000 fine, or they're going to say, line it up, come on, I got to drive.
Because think about what you saw just now, okay? I mean, it meets all the criteria for an effective ad. Memorable, gets your attention, you know, all those things. But what is the bottom line here on all this? First of all, as an attorney, you can't do any of this stuff. You can't combat this because you can't use absurdity and things of that nature. You can't use music. You can't use these types of dramatizations. But what this is doing is it is cheating the people who buy this insurance, robbing them of the opportunity to get just compensation for their injuries, not telling them that they're spending the maximum amount of money they could possibly spend on the minimum amount of coverage, and destroying the plaintiff's bar, at least in terms of traffic accidents at the same time. So, but let me get off my soapbox here, because really I want to kind of get back to ethics. Do you guys all now have like a little bit of understanding of how the whole, ethically, how the whole system of advertising works in New Jersey? See why we call it barely legal? Because it's so simple. It's like falling in love. It's so easy to fall in love. It's so easy to make ethical mistakes when you're putting an ad together. When you're doing it, familiarize yourself with the CAA requirements. Take a look at the court rules I've given you here. If you have a question, call me. I'll be happy to talk to you about it. Remember, the best type of advertisement is the advertisement that works. You just got to do it in conformity with the rules of the game as given to us by the Supreme Court.